David Zambrano.
How you doing today?
Doing all right. It's a Tuesday. We got lots to do and we're making progress. Mr. Zambrano, we've had a hard time getting you in here. We got a lot going on here. In file 251521, you got a ticket on July 29th for driving without insurance and no valid license in possession. Those are both written under state statute. On July 25th, you got charged with driving with an unregistered vehicle in file 1523. On July 14th, you got charged with driving suspended and unregistered vehicle. That one's under White Pigeon ordinance. So July was a bad month for you. Then we said this a couple times. The city or the village of White Pigeon in the July 14th case has agreed to dismiss the charges if you plead to allowing another to violate the motor vehicle code. I'm not sure what the county's position would be on the other charges. And frankly, I don't know why they didn't charge him with driving suspended on all three.
The courtroom session begins with Judge calling David Zambrano to the stand. Right from the start, the judge notes that it's been difficult getting David to appear in court. As the charges are read, the picture becomes much clearer. During the month of July alone, David was cited multiple times for driving without insurance, driving an unregistered vehicle, and driving without carrying a valid driver's license. One of those incidents even involved driving while his license was suspended. The judge also reveals something important. One of the local charges could be dismissed through a plea agreement, showing that the court is willing to consider resolving part of the case without going to trial. However, the number of repeated violations raises serious concerns. The judge even remarks that he's surprised additional suspended driving charges weren't filed in every incident. Already, the courtroom atmosphere suggests this case isn't about one simple traffic stop. It's about repeated legal problems that have continued without being corrected. What do you think? Should someone who repeatedly ignores traffic laws receive another opportunity to fix the situation, or should stricter penalties apply?
Days. Let's take a look. And then you missed a date, and then they reset it, and I don't know what happened, but
Your Honor.
yes.
I'm appearing here today, pro se, in the special appearance sui juris and in propria persona. I respectfully assert my rights to represent myself and have my constitutional rights recognized and upheld throughout these proceedings.
All right, well, that's certainly your right.
Thank you, sir.
You live in South Haven?
Actually, I'm the sojourner of the land. I don't have a residency at the
Well, the reason I ask,
I once did,
if
sir.
I need to send you mail, I need to know where to send it.
Right now, I do not have an address.
All right. Well, you do certainly have a right to represent yourself, and I don't have a quarrel with that. What do you want me to do? Set these for a trial? Or set a pretrial on all of these? Some are under White Pigeon ordinance, some are under state statute.
The hearing takes an unexpected turn when David announces that he wishes to represent himself. The judge immediately acknowledges that this is his constitutional right. However, the conversation quickly becomes unusual. When the judge asks where court documents should be mailed, David responds that he owns land but doesn't have a residence or mailing address. The judge calmly explains that the court simply needs an address to send official notices. Even this simple administrative question becomes more complicated than expected. The judge then asks David how he wants to move forward. Should the cases go directly to trial or first be scheduled for a pretrial conference? Rather than focusing only on punishment, the judge offers practical advice. He encourages David to obtain insurance, register his vehicle, and work toward getting his driver's license reinstated. According to the judge, solving those issues would greatly improve David's situation before the next court appearance. Sometimes, fixing the original problem can be far more effective than arguing about it in court.
You can help alleviate this by getting insurance, getting a license. It looks like you have some out-of-state problems. And you haven't had anything on your Michigan record in a long time. 12 years or more. So how would you like me to proceed here?
What are the charges? Again, all the ones that.
Well, right now, you're not doing a very good job of representing yourself because you don't even know what you're charged with. Let me tell you again. You're charged with no insurance. That's a misdemeanor, punishable by up to a year in jail, a fine of not less than $200 and not more than $500. That was on July 29th. On that same day, they charge you with no valid license in possession, even though your license is suspended. They didn't charge that. No operator's license in possession is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. On July 25th, take a look at that one. No, that's the 29th. It's the same as the others. You got no insurance, no ops on person, unregistered vehicle. That was on July 29th. And those are all under state statute. On July 14th, you got another ticket. Take a look at that one. 1560.
As David struggles to answer how he wants to proceed, the judge notices something concerning. David asks what the charges actually are. That prompts the judge to remark that representing yourself becomes difficult if you don't fully understand the accusations against you. The judge patiently goes through every charge again, explaining each one in detail. He outlines the possible jail time, fines, and additional consequences attached to driving without insurance, failing to carry a valid license, driving with an unregistered vehicle, and driving while suspended. Instead of rushing through the hearing, the judge carefully explains each offense and the possible penalties so there's no misunderstanding about what's at stake. This moment highlights an important lesson. Representing yourself doesn't simply mean speaking on your own behalf. It also means fully understanding the law and the charges you're facing. Would you ever choose to represent yourself in court, or would you always want an attorney beside you?
And that one, they filed a formal complaint that alleges that you were driving suspended and you had an unregistered vehicle. And that is under White Pigeon ordinance. Driving suspended is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. That carries 2 points and it requires that your license be suspended. And then they charge that you have an unregistered vehicle. You could help all of these if you got insurance, a registered vehicle, and worked on getting your license back. So one thing I could do is set all these cases for a pretrial on the same day with the White Pigeon Village attorney and the county attorney and see if they can come to some resolution of all the charges. Is that acceptable to you?
Actually, no, I have a few questions I need answered before we proceed. I don't understand the nature and the cause of this action against me. And I'm is this a civil or criminal? It's criminal.
All right. You were here with your mom and she's here with you. So it's good that you support each other. She asked me the same question, which points out to me that you're not qualified to represent yourself if you don't.
After reviewing every citation, The judge once again tries to guide the hearing toward a practical solution. He suggests scheduling all of the pending cases together for a single pretrial conference involving both the county prosecutor and the village attorney. Rather than immediately preparing for trial, the judge believes both sides might be able to resolve many of the issues if David first gets his paperwork in order. Insurance, vehicle registration, and license reinstatement remain the judge's primary recommendations. However, David isn't ready to agree. Instead, he says he doesn't understand the nature and cause of the action against him and asks whether the matter is civil or criminal. The judge immediately answers that these are criminal cases. That answer seems straightforward, but it marks the beginning of a much larger disagreement that will dominate the rest of the hearing.
The difference between a criminal matter and a civil matter. These are criminal matters. They could result in a jail sentence and a sanction on your driver's license.
Thank you, Your Honor. Should the record reflect this is a criminal action then?
Yes, it is.
Okay. I just got to look at my papers and stuff.
All right.
So my next question about it is, Constitution grants this court two types of jurisdictions.
Yes. All right, we're not going to get into this, what I call jabberwocky. It has no legal effect. I don't know where you get it or where your mother got it, from a online source or somebody that told you this, or they're giving you bad information. These are criminal matters. They're not terribly consequential. Normally, you wouldn't go to jail for these, although they do carry a potential jail sentence. You don't necessarily subscribe to our system, but I certainly don't subscribe to whatever you got written on the paper there. I propose we set this for a pretrial, and you try to get a registration and insurance, and then come in and share it with the prosecutor and the city attorney, and see if we can resolve everything. If we can't, we can set it for a trial, including a jury trial, I suppose. It's two different incidents. So
once the judge confirms that the case is criminal, David begins reading from prepared documents and starts asking questions about constitutional jurisdiction. The judge quickly recognizes where the discussion is heading. He remarks that David and even his mother appear to be relying on information they've likely found online, suggesting that the material is giving them incorrect legal advice. The judge openly calls these arguments jabberwocky, explaining that they have no legal effect inside his courtroom. Even while disagreeing with David's legal theories, the judge remains focused on moving the case forward. He repeats that these are statutory criminal offenses and again proposes a pretrial conference where both prosecutors can discuss possible resolutions. This exchange creates one of the biggest moments of tension so far. One side wants to discuss legal theories about jurisdiction, while the other wants to focus on resolving the actual criminal charges. Who's making the stronger argument here? The judge insisting on procedure, or the defendant demanding more legal explanations before moving forward?
it would have to potentially be two different cases. What I propose is you trying to do some things to get situated and have a pretrial with the city attorney and the county prosecutor.
Your Honor, I'm going to have to object to that. Before we can proceed, I need to know, it's upon the authority of the Sixth Amendment, I need to know the nature and the cause of these charges. Could you tell me if it is a common law?
No, these are statutory offenses written under the authority of the people of the state of Michigan. One of these is under the insurance code and one is under the motor vehicle code. The others are. And I don't really wish to engage in this discussion. We've got about 40 other people waiting for their case. And you want to talk to me about how many angels can fit on the head of a pin. You're charged with two separate traffic offenses on two separate occasions. You have a right to have an attorney. I'd be happy to appoint one for you, but you don't want one. You want to represent yourself, which is your right, but you don't have the right to waste my time. So if you either want me to set it for a pretrial, I can do that. That would be my preference. Then you can sit down with both prosecutors, ask these questions, and see if it can be resolved. If it can't, we can set it for a trial, either in front of a judge or a jury.
David continues objecting. He insists that before anything else happens, the court must explain the authority behind the system and clarify whether these charges fall under common law. The judge responds directly. He explains that these are statutory offenses created under Michigan law, including the insurance code and the motor vehicle code. He also makes it clear that he doesn't want to spend valuable court time debating theories that won't affect the legal proceedings. With many other cases waiting to be heard, the judge reminds David that he has every right to hire an attorney, or even have one appointed. But he doesn't have the right to delay the court by refusing to move the case forward. Despite the growing frustration, the judge still leaves the decision open, pretrial or trial. The court continues offering options instead of punishment, but the disagreement over legal procedure keeps slowing everything down.
So what would you rather do here today?
Well, on the authority of the Sixth Amendment, I'm asking that the court discloses the jurisdiction that I ask.
I just did.
You
So
said it's a statutory
It's-
jurisdiction?
yes, you're
So
supremely unqualified to represent yourself in this matter because someone sold you a packet of information that has no relevance in the modern universe that we live in. So I'm gonna set this for a pretrial.
Your Honor, that would be practicing law from the bench if you proceed without me.
I'm a lawyer, I'm a judge, I practice law from the bench, I do it every day, all day. And
I'd like to, I do have a few more questions about the.
I don't
statutory.
have any more time to answer your questions. I have a question for you. What do you want me to do with it? Set it for a pretrial or set it for a trial?
Under a statutory jurisdiction, I've never heard of, I need to know where I can find the published rules of the criminal procedure under that.
Well, you can certainly find them on the internet. They're in the public library. You just put the number of the citation, 257904 under the Michigan compiled laws.
Even after receiving several explanations, David again invokes the Sixth Amendment and asks the judge to disclose the court's jurisdiction. The judge responds that he has already answered that question and confirms once again that the case proceeds under statutory authority. Then comes one of the hearing's strongest remarks. The judge tells David that he is supremely unqualified to represent himself because someone appears to have sold him legal materials that have no relevance in modern courts. David argues that the judge would be practicing law from the bench if he continued without answering additional questions. The judge responds with a touch of humor, saying that he is a lawyer and a judge, and that practicing law from the bench is exactly what judges do every day. Although the exchange becomes tense, the judge remains determined to move the hearing toward a practical resolution rather than a lengthy legal debate.
Was that
Mr. Stickley is the chief public defender. He's had an opportunity to talk with you. Mr. Stickley, what's your recommendation here?
My recommendation would be to set it for a pretrial. I'm happy to spend a few moments with this gentleman and show him where the statute is
All
and
right.
maybe where he can Google or library.
And he's entitled to have copies of each of the tickets and the complaints, and so he can see it. So if you'd like, we'll get copies of their tickets for you. You got the ticket, but there's a formal complaint. I'm gonna set it joint with the city and county for 2 weeks. October 7. Mr. Stickley is the chief public defender, and he's not exactly representing you. He's here to make sure that your rights are protected. And he also can give you some advice and maybe point you in the direction of what you want to do. Again, it would be helpful if you would come in with insurance and a proper plate and perhaps an effort to get your license back.
Recognizing that the discussion has reached a standstill, the judge asks the chief public defender for his recommendation. The public defender agrees that a pre-trial conference is the best option. He also offers to spend time showing David where the relevant statutes can be found and explains that copies of the complaints and tickets will be made available to him. This is an important moment because, rather than simply dismissing David's concerns, the court offers additional resources to help him understand the legal process. The judge schedules a joint pretrial hearing and again encourages David to take practical steps before returning to court. It's another reminder that the court is giving him opportunities to improve his position before any final decisions are made.
Don't want to stay on the driving suspended merry-go-round because it's very hard to get off of it. Once you get suspended, you live near White Pigeon. The other problem is I don't have an address for you. So I need a mailing address. When you go out to we can use your mom's address but I'm gonna need you to give the clerks some sort of address where we can send things to you.
Could you deliver it general delivery to the post office?
Well, you can give them that.
Okay.
All right, I'm gonna want you to take him out, get him a proper notice for that pretrial on the 7th. Mr. Stickley will meet with you and get some of that information that you're looking for. All right, sir, I'll see you on the 7th.
As the hearing concludes, the judge once again advises David to obtain insurance, register his vehicle properly, and work toward restoring his driver's license. He also stresses the importance of providing a mailing address so the court can communicate with him about future hearings. The judge officially schedules the pretrial conference and asks the chief public defender to assist David in locating the legal materials he requested. Rather than issuing an immediate ruling on guilt or innocence, today's hearing ends with the court choosing preparation and negotiation over confrontation. Overall, this case demonstrates the challenges that can arise when someone chooses to represent themselves without fully understanding criminal procedure. While every defendant has the right to self-representation, that right also carries the responsibility of understanding the law, the charges, and the court's procedures. Throughout the hearing, the judge repeatedly attempted to steer the discussion back toward practical solutions instead of theoretical legal debates. Now we'd love to hear from you. Do you think the judge handled this situation fairly, or should he have spent more time answering the defendant's constitutional questions? Share your opinion in the comments below. If you enjoyed this courtroom breakdown, don't forget to like this video, subscribe to the channel, and turn on notifications so you never miss our next courtroom analysis. Thanks for watching, and we'll see you in the next case.